Syracuse Living Trust Lawyer. A living trust can help you stay in control of your assets while making future planning easier for your family. In New York, a living trust is a legal document created during your lifetime to hold and manage your assets. Because it is revocable, you can change, amend, or cancel it while you are mentally competent. Most people serve as their own trustee, which means they keep full control over trust property during life. You can still buy, sell, invest, and manage assets in the trust just as you do now. The main difference appears if you become incapacitated or pass away, because a successor trustee can step in without court involvement. For many families in Syracuse, one major benefit is avoiding probate in the Onondaga County Surrogates Court. Probate can create delays, court costs, legal fees, and difficulty accessing assets titled solely in your name. A properly funded living trust can allow assets to pass to beneficiaries without that probate process. Another benefit is privacy, because a will filed for probate becomes a public record, while a living trust remains private. A living trust also helps with incapacity planning by allowing your chosen successor trustee to manage trust assets if you cannot do so yourself. That can help your family avoid a guardianship proceeding that may be expensive, time-consuming, and public. A will and a living trust are not the same, because a will takes effect only after death while a trust becomes active once it is signed and funded. A will also does not manage your affairs during incapacity, but a trust can provide that framework. Many estate plans still include a pour-over will to catch assets that were not transferred into the trust and to name guardians for minor children. Creating a trust usually starts with a conference to review your goals, family circumstances, and the assets you own. An attorney then drafts a trust agreement tailored to your situation, including successor trustees, beneficiaries, and instructions for management and distribution. Funding the trust is a critical step because an unfunded trust does not accomplish its purpose. Assets commonly placed into a trust include real estate, bank accounts, investment accounts, business interests, and valuable personal property. Retirement accounts like IRAs and 401ks are generally not retitled into the trust, though beneficiary designations may still be part of the overall plan. A revocable living trust does not by itself reduce estate taxes, because the assets remain part of your taxable estate. The page explains that for deaths in 2026, New York's basic exclusion amount is $7,350,000 and the federal filing threshold is $15 million per person. Living trusts can also be tailored for blended families, minor children, out-of-state property, and loved ones with special needs. Choosing the right successor trustee matters, because that person may need to inventory assets, manage property, pay debts and taxes, keep records, and distribute trust assets according to your wishes. Davies Law Firm says its estate planning lawyer team has helped Central New York families create living trusts and related plans since 1993. If you want guidance from a Syracuse attorney or lawyer about creating a living trust, Davies Law Firm can be reached at 315-472-6511 at 210 East Fayette Street, Syracuse, New York, 13202, United States.